Good morning, everyone. My name is John Cornwell, and I'm the Marketing Director here at Plunkett Cooney. I'm pleased to help out as coordinator for today's program, which we're hosting exclusively for members of the Petoskey Regional Chamber. In light of Governor Whitmer's recent COVID-19 executive orders, many of Michigan's businesses are now back to work, as you know, and others are planning to reopen soon. So that's why we're taking time out today to explore how to return to work safely and in accordance with best practices put forth by the scientific and medical communities. Fortunately, we have with us today Laura Dinon, who's a member of Plunkett Cooney's Labor and Employment Law Practice Group. Like her colleagues at the firm, Laura's been studying this issue for weeks now, so we're glad to have her here with us today as our featured speaker. Before we get started, I'd like to take a few minutes just to provide you with some background about Laura and our law firm. For those who don't know, Plunkett Cooney is based in Southeast Michigan and is one of the Midwest's oldest and largest law firms with approximately 140 attorneys. We have offices in 7 Michigan cities, as well as in Chicago, Illinois, Indianapolis, Indiana, and Columbus, Ohio. Our Petoskey office has been around since 1988, and it provides a full range of business, employment, and litigation services. The firm's employment law practice group includes more than 20 attorneys who work in the areas of traditional labor law, human resources consulting, employment litigation, and workers' compensation. So let me take a moment now to introduce you to our featured speaker, Laura Dinon. Laura has over 30 years of experience advising employers. She's built a successful practice representing public and private sector employers of all sizes throughout northern Michigan. Her expertise includes traditional labor and all types of employment law matters. She's a past president of the Petoskey Regional Chamber of Commerce and a past president and currently the secretary of the board of directors of the Northern Michigan Society of Human Resources Directors. So now just a couple housekeeping notes and we'll get started. For the Q&A portion of our webinar, we're going to use our questions widget on our GoToWebinar navigation display. If you could just take a moment to locate that widget, you could feel free to type in questions as they occur to you during the program. At the end, we'll try to answer as many questions as possible. We ask that you try to pose questions that are of a more general nature versus something really specific to your workplace. That sometimes can get sticky for us, and we try to keep the questions at a little higher level, more general nature whenever possible. The other thing I want to point out is in the handouts section of your GoToWebinar display, you should see the slide deck for today's program. So you can feel free to go ahead and download that if you need them. And those are handy to have even for making notes. Finally, I want to mention that today's session is being recorded and that we're going to make that recording available to the chamber so that it can be posted for you to listen to again or for the chamber to share with other members. So with that, I'm going to turn over the program to Laura. Laura, go ahead and take it away.
Thanks, John. Good afternoon. I guess it's morning, isn't it? Good morning, everyone. Almost afternoon. I just thought it would be kind of timely, and Nikki and Lisa agreed, to go over some of the executive orders that are still out there and give you some reminders about things to keep in mind as the world reopens. So I'm going to briefly go through the current status of some of the applicable Michigan executive orders, talk about some concerns that you should have when you're resuming in-person business activities, talk about some applicable administrative guidances, and then hopefully if you have questions, I'll be able to answer them. And I have attached a number of questions at the back of this that I think I've been fielding from clients, and so I'm going to run through those too, and they may answer questions you have that you never even thought of. So the first order that really opened things up was Executive Order 2020-77. This reopened manufacturing and construction probably about 3 weeks ago, and it gave very specific guidelines for reopening those industries to start everything off. If you are not just now reopening a manufacturing facility or bringing back construction workers, you should review the specific things found in that order. I'm not going to spend any time on them today because I think a lot of those employers are already back in the workplace. Executive Order 2020-97 is a very explicit order that the governor put out when she reopened Northern Michigan, which applied to all of us a couple of weeks ago. This order requires employers to conduct a daily entry screening protocol for your employees and any contractors or customers or anyone else that enters your facility. You have to greet everyone with a questionnaire that covers the symptoms and suspected or confirmed exposure to people with possible COVID-19. Some of the daily screening questions you can ask and should ask are found on this screen. Have you been in close contact with a confirmed case of COVID-19 within the past 14 days? And close contact under the CDC guidelines is within 3 to 6 feet for 10 minutes or longer. Have you had a fever or felt feverish in the last 72 hours? Are you experiencing any new respiratory symptoms, including a runny nose, sore throat, cough, or shortness of breath? Are you experiencing any new muscle aches or chills? Have you experienced any new change in your sense of taste or smell? And have you traveled on an airplane internationally or domestically within the last 14 days? You may also, if it's applicable to your business, ask if they've traveled out of state on a driving trip. It may be something that you want to know. So if people get through the daily screening questions and can answer no to all of these questions, then you should be good to go to let them come to work. If they answer yes to any of these questions, you may either send them home, or you may want to take the next step of taking their temperature. I don't recommend temperatures of all employees unless it's required, which it is in manufacturing and in construction. But I think that it's appropriate if you have somebody who, for lack of a better term, flunks a daily screening question to determine if you want to send them home. The order to resume activities requires every employer to develop a COVID-19 preparedness and response plan. And you can do this by clicking on the OSHA website and looking at their guidance on preparing the workplace for COVID-19. They have the very specific requirements in there, and it'll really set out what you need to include in your plan. This preparedness plan had to be completed by June 1st or within 2 weeks of resuming activities in your workplace. You have to post the plan or disseminate it to employees and customers. You can put it on a website. You can have hard copies available. You can post it. You can email it to people, but everybody has to know what it is, and you need to follow it. One of the things that you have to do as part of this resuming activities, and it would be included in your preparedness and response plan, is to train your workers on various COVID-19 related issues. You should educate and train everyone on your workplace infection or control practices that either are in place or that you're putting in place. The proper use of PPE, whether it includes gloves. Everyone is supposed to be wearing masks in any public enclosed or indoor space. And in general, it's a good idea wherever they go, but these are specific to the workplace. So proper PPE use training, make sure the mask covers the nose and mouth. And you need to train your workers on what to do if they have symptoms, have tested positive, or they've been told that they have a suspected case of COVID-19. or even if they've been exposed. And who do they notify? How do they do that? For instance, you don't want them coming into work to tell you that. So who do they call? If they're at work, what do they do? Stay in their office or at their workstation and call someone to tell them? You've got to think these things through and then train your workers on what you want them to do to handle this. And that kind of jumps into the next step also on how to report unsafe conditions. And that can be someone sick in the workplace, but it could also be someone who feels like they're interacting with people in an unsafe way in work, whether it's having to sit too close to someone without having, a plexiglass border, dealing with the public that are being allowed to come in and not wear masks, whatever it is, they have to have an avenue to report those unsafe conditions. And you certainly want them reporting them internally rather than calling MyOSHA or OSHA. So as part of resuming activities, you're going to do this daily self-screening. You're going to require everyone and assist them in keeping 6-foot social distancing. As an employer, you have to provide PPE that's necessary in the workplace, and at a minimum, this includes face masks. And if you can't social distance everyone due to the nature of the job and the work site, if they can't be 6 feet apart, then you have to require all the employees in that situation to wear face coverings. If they are more than 6 feet apart, there's some discretion for employers to decide, say, if you have individual offices or separated workstations, that if an employee gets into their office, then they can take the mask off. But it's really highly suggested that for most movement in offices, even if they're not technically public spaces, that face mask be worn the entire time. You have to adopt cleaning and sanitizing protocols and make those cleaning and sanitizing supplies available. For training purposes, there's a lot of web-based programs out there, and that would be one idea, especially if you're not quite up and running. If you can find a good online training program in cleaning protocols, PPE protocols, social distancing, those sorts of things, then you could even get your employees watching that during their downtime. Whatever way you choose to train your employees, make sure you document that you did it and document that they attended. You have people sign off on a handbook when you put a new handbook out there. Make sure that they sign off, whether it's a sign-in sheet, shooting you an email, checking off a box, something to show that they actually went through the training. If webinars don't work for you, you can do pre-shift training at the start of every shift where there are new people coming back to work. And even if, if you have pre-shift meetings anyway, you could do refresher every time on just the major basics of what you want them to take away regarding COVID-19 safety. You can disseminate written materials and again have them acknowledged receipt in a format that you can save. And if you do find generic training materials, make sure that it matches what you're actually doing and matches what you can do in your location. It's a really bad thing to find a good training, but the training has no applicability to your workplace. So, once you find the training you want to use, again, there's a lot of good ones out there and probably a lot of them are free, but make sure if you're going to use something like that, that either you tailor it to your work site or find one that is tailored to the same situation you're in. And again, if you start with a canned one, you can add in the language that fits you, and you could also add some language that allows you to modify and update your policy as time goes on, because many of us are going to find that things we thought would be perfect don't quite work when you bring everybody back. And so you're going to have to shift some of your policies. And so you want to, it's going to be more of a fluid document for training purposes. As part of your resumed activities, you have to, under the governor's order, designate one or more supervisors to implement, monitor, and report on your COVID-19 control strategy. And that designated supervisor or supervisors, one of them has to be on site during all times that employees are present. That's a pretty burdensome thing. So you need, probably you're going to need to train more than one supervisor or manager, and you're going to have a trained supervising person on site during all hours where employees are present. If you have a positive case in your workplace, which is going to happen, hopefully not a lot of them, but as the world opens up and we have more contact with the outside world, there's high potential that somebody is going to get exposed and come into the workplace. So as an employer, you're going to have to notify potentially exposed individuals once you know that someone's been in your business that tested positive for COVID-19. So if you're retail or hospitality and you know that somebody reported to you even that a customer was in your business and tested positive, any employees that work that shift should be told that there's potential that they were exposed and to watch themselves for symptoms. And you have to be careful as an employer that you don't give out, personal medical information. Don't identify the person, but just say we've been advised that you may have come into contact when you worked last Wednesday afternoon. And so be alert and watch yourself for symptoms for the next however many days, adding up to 14. If somebody is in the workplace and sick, isolate them immediately and send them home without further contact with other people. And if it's really important to encourage your employees to report to their supervisors or managers immediately if they experience symptoms and are concerned they might have been exposed, because A, you want to keep them out of the workplace, and B, you want to try to contain it, figure out who they've come in contact with and alert those people to that they may have been exposed. And you could consider testing. The testing is opening up here, but you want to know. So encourage people to tell you, and you can't retaliate against any employees who've had it, been exposed, or bring issues to your attention. That was Executive Order 2020-36, and that is still in place. So if you want to check out the requirements on employers with respect to no retaliation, discrimination, etc., that's the order you want to look at. So again, if you have positive cases in the workplace, you need to shut down the areas where the sick worker was, clean and disinfect. And there is a requirement under the executive order that you have to notify your local health department within 24 hours if you have an employee who's diagnosed with COVID-19. And that's to allow them to come in and help you with the contact tracing and to try to contain any outbreaks. And you can't allow employees to return to work until they're no longer infectious. There are, I can't think of the executive order right now, I'm sorry, but it might have been 96, but the governor has laid out staying home rules, but you can also find them on the CDC website. And basically, I believe it's 72 hours symptom-free and at least 7 days from the day the symptoms first appeared. So if they meet both of those criteria, they're no longer infectious and you can bring them back to work. EO 2020-97 sets forth really pretty explicit instructions and requirements for a lot of specified categories or industries. It has rules for outdoor businesses, construction, manufacturing, laboratories, retail stores, restaurants and bars, offices, medical offices. So if you go to that order, just Google michigan.gov and click on coronavirus and then drop down to the executive order bar and search for 97. You can get the exact information you need regarding your particular business and industry, as well as all the, I've touched on a lot of the requirements, but you might want to read that order. That's the one that really outlines what employers have to do to bring people back into the workplace. And then the order that allows you to reopen, well, up here it was 91 and 2, I think. But the one that opened the rest of the world, which is going to open the floodgates for us, is EO 2020-110. And this is the order that the governor, it's not her most recent order. There are more recent orders, but it's the one that opened up the world in the last few days. So this order reopens the whole state unless you are in a business or industry listed in the order. So it reverses. Before, she was slowly allowing a particular industry to open. Now everyone's allowed to open unless you are specifically identified as one that cannot open. And basically by June 8th, all but the specified industries can reopen. Some can reopen today and the rest can reopen on June 8th. This order requires anyone leaving their home to wear a face covering in enclosed public spaces. It also allows gatherings, social gatherings of no more than 10 unrelated persons in personal homes, and social gatherings of no more than 100 unrelated persons in outdoor spaces. But the kicker is you still have to maintain the social distancing. And one interesting thing that hasn't really been brought out, I don't think, in the news releases, is this order says that businesses and building owners can deny entry to persons refusing to wear masks unless they fall, they're kids under 2 or there's a medical reason. But if it's just people who don't want to wear one, a business owner or a building owner can keep those people, deny them entrance to their building, deny them service, and the business will not face liability for doing that. So if you are in a business where you might have issues with that, you can look to this order for protection, that if you choose to require people to follow the rule and wear a mask, you can deny them service and they cannot sue you.
Hey, Laura, it's John. Real quick, Laura, can I interrupt for just a second? There's a question that's right on point to this slide. It's regarding outdoor spaces. And the question is, does the order define what an outdoor space is? For example, would a party tent with or without sides be considered an outdoor space, if you know?
I don't for sure, but I would consider it with sides to be an indoor space. And without sides, I think that it would be okay to the extent you can. I'd make sure you do the social distancing. The idea is that fresh air disperses the germs, and so for sure sides I would consider an indoor space. I haven't seen any guidance on just a covering tent, but outdoor spaces in restaurants with overhead roofs but no sides, I believe, are considered outdoor spaces. So I would think that would apply to a tent also, if it had no sides. So hopefully that answers your question. Under EO 110, returning people to work, you're supposed to keep all of your employees working remotely if their job can be done remotely. They can come back into the office or the workplace if necessary, but the idea is to still space people out as much as possible. So if your employees can successfully work from home, then it actually states you must continue to work remotely. I don't think anyone will be out there enforcing it, but just know that you may have employees who point that out to you. If you're resuming in-person work, you have to follow Executive Order 97, which we've talked about at some length. Outdoor pools and recreation spaces such as playgrounds can reopen. Libraries and museums can reopen. The businesses identified in the order that must still remain closed are gyms, exercise places, things like that, where there are a lot of surfaces where germs can be spread. It's an enclosed space and people come in close contact with each other. The same for hair salons, nail salons, spas, things like that. They are still closed. There's been some suggestion that she's going to loosen that up in the next week or two. And in fact, I've heard that she plans to move into stage 5, which everything will reopen by the 4th of July. But for now, no gyms, hair salons, no indoor theaters, no tattoo parlors, no casinos, or places that are similar to those kinds of things where people have to be in close physical contact. And there's a lot of shared spaces and potential for germs to spread. So those cover the Michigan governor's orders, but I wanted to touch on a few of the federal laws just as reminders. There's I gave a website for the EEOC, and this has a lot of good information about their position on COVID-19 and its interplay with the ADA and the Rehab Act. In May, the EEOC elaborated on their advice for disability accommodation requests and harassment. They added a section regarding employees returning to work after the pandemic. The EEOC takes the position that, as you would expect, that the ADA and the Rehab Act and all the other EEOC enforced laws still apply during the pandemic. They have loosened some of their enforcement restrictions, but these laws still apply and you can't just disregard them. Employers can still follow guidelines and suggestions from the CDC and state and local public health authorities. The EEOC has kind of deferred to them with things like the health screening, pre-shift health screening in our old normal would have been a questionable violation of the ADA, and the EEOC is saying no, it basically takes precedence because first of all, you're doing it for everyone, and if you're asking it properly, it shouldn't identify a disability, to single people out. And also, it's okay because there's a pandemic and public health takes precedence. So the screenings are okay. The temperature taking, they take the same position on that. So if you're in an industry where you're required to, or you choose to do temperature screening, that's being allowed by the EEOC. They're recognizing that that's a legitimate concern that employers are addressing, and it's not targeting people with disabilities. Critical infrastructure and essential critical workers are still covered by the ADA and the Rehab Act. So, for instance, if you're in a healthcare industry and our governor's order says that you aren't necessarily allowed to take paid sick leave or you can be forced to go to work, and under the federal laws, you can't take paid sick leave, you don't get the expanded FMLA, but the EEOC says that may be true, but the ADA and the Rehab Act apply, and therefore, if you have an employee with a disability that needs time off, they may get it under the ADA, even if they couldn't get it under the Paid Sick Leave Act, or could be forced to work under any of the executive orders. So don't forget that those laws are out there, and you have to just take it into consideration. Okay, so the ADA allows employers to make disability-related inquiries and conduct medical exams as they are job-related and consistent with business necessity. That's the general rule that applies all the time. Excluding employees with a medical condition that would pose a direct threat to health or safety may meet this standard. So if you do COVID-19 testing or screening and you use it to exclude employees from the workplace, that's allowed. And it's kind of a bad example because COVID-19 would not necessarily be a disability for purposes of the ADA. Not all sicknesses are. It's a more of a long-term situation, but it just shows how they're kind of going out of their way to allow you to do these screening things. And I've had some employers who have been having to do the ADA analysis depending on the job. There's some first responders and healthcare employers who have employees where we've had to do direct threat analysis, and the rules are still in place. So if you need help with any of that, you should probably consult your attorney because it's pretty complicated. But the takeaway I want you to have is that you've got to follow the guidelines. So if employees don't seek a reasonable accommodation, then the employer doesn't have to take any action. But if an employee does seek a reasonable action, or reasonable accommodation, then you have to think about the ADA. And a reasonable accommodation could be someone who feels vulnerable and requests remote working, even if everybody's called back to the workplace. And then they might be required to go to work by your policies, by the governor's order, but they might be protected under the ADA. If remote work works for them, then that would be considered a reasonable accommodation. You don't have to be out there offering it, but if you have employees with disabilities or are in vulnerable positions and they request it, then you have to do the ADA analysis. If you as an employer think your employee might be a direct threat to his or her health or that of others, you have to do the direct threat analysis. It's a high standard to show that an employee is a direct threat, but it's important to remember it's out there. And even if you go through the analysis and determine that the condition of the employee is a direct threat to their own health or to others, you can't necessarily keep them out of the workplace if there's some other accommodation available that isn't an undue hardship. So it's a multi-step process. You have to go through the interactive process and do the analysis, whether they request it or whether you think that they if you just think they need an accommodation, you can't initiate it as the employer. But if you think that they pose a threat in the workplace, then you can initiate it, do the direct threat analysis, and then you have to determine there's a reasonable accommodation that would allow them to perform their essential functions but eliminate the direct threat. Next slide, John. The EEO guidance tells us, I'm not sure if I'm missing a slide or not, but you cannot select employees for disparate treatment based on their national origin. They're closely watching, and the CDC actually warned of prejudice against Asians because there's been a lot of talk at the federal level of how this came from China and we should ban all Asians from the U.S. And you, as an employer, you have to be on the lookout for these types of things happening in your workplace. I don't know how prevalent it will be in our area, but just be alert to it because, again, the EEOC laws are not suspended. They have given you some wiggle room, especially with respect to medical conditions, but harassment laws, those types of things are still out there. And you cannot pick and choose who you're going to bring back into the workplace based on protected categories like national origin. One of the things they're seeing nationwide with respect to this is coworkers don't want to work with particular people for whatever reason. They perceive them to be a threat to their health and safety. It might be someone who is of national origin that they think would be a carrier. It may be that someone had COVID-19 and they're worried that they can get it from them. And so you have to have ears and eyes on the ground. And one way to do this is all those supervisors that you have to train and be on site during every shift. That should be part of their training, to be aware of the potential harassment and discrimination issues out there. So employers should be closely monitoring concerns in the workplace of disparate treatment or harassment because of national origin, and I suggest because of medical conditions. And this can include employees avoiding a targeted person for whatever reason. So it doesn't have to be, overt harassment. It can just be an avoidance situation that makes the person feel singled out and treated unfairly. On the other hand, if you have employees who've traveled internationally, including to China or other Asian companies, you can make them self-quarantine for 14 days when they come back, or if they have symptoms. So it would be based on objective facts, not just their status of a protected category.
Hey, Laura, it's John. Real quick, there was a question that's been out here for a bit. If someone is tested or is waiting for results of testing, can you talk just briefly about what the pay requirements may be for someone like that that's waiting for results?
Okay. Under the Paid Sick Leave Act, that person, if they have tested positive or are waiting test results, they would get paid for up to 2 weeks or 80 hours. It's based on their actual work hours. So if you have a 35-hour-a-week employee, it would be 70 hours. It's based on their actual work week. But, excuse me, up until the test either comes back positive and they have to wait out that 7-day period and 3 days symptom-free, or they get a negative test. They get paid 100% of their pay, up to $511 a day, and the employer pays that, but the employer gets that back from the federal government by withholding payroll taxes, which is more of an accounting function, and you should talk to your accountant about it. You pay them normally, but you don't eat the cost. The federal government is going to pay that. Your employees are only entitled to one time 2 weeks up to 80 hours. If they don't use it all at one shot, they would still say if they use 1 week, they'd have another week coming. But once the 2 weeks are used, the employer can't get a tax credit, and you don't have to offer them any additional time under that law. However, if you are an employer of 50 or more and you are covered by Michigan's Paid Medical Leave Act, that's separate. And so they would have to be allowed to use any hours they have available under that act. If the actual employee is not sick, but they need time off of work to care for a family member who is sick, then they get paid at 2/3 of their regular pay for 80 hours or up to 2 weeks up to 80 hours. And the max on that is $211 a day. And again, it's paid by the feds. So hopefully that answers that question. So
I was just going to say, just to add to that real quickly, there are recorded events on our website. So anybody that needs more information about that can check out our website event pages. We've covered this issue in detail separately, so check that out.
Yep. Thanks, John. That's true. So next slide, John. I think I put some questions on here. So when should you require your employees to be tested or perform on-site testing of employees? If you're in the healthcare industry, you probably are going to want to get them tested. If you have employees who are showing symptoms or fail a temperature test, you should send them to be tested. And it's my understanding that testing is now available up here without a prescription. And there are kind of mobile sites moving around. And if you call the health department, they can direct you on how and when these employees can get tested. It's free. So testing if they are exhibiting symptoms, report symptoms, or fail a temperature test. If you're a big employer and want to do on-site testing, you can set that up, but I don't think everybody has to do the testing. This next one's a tough one. How do we ensure the safety of vulnerable workers without engaging in unlawful age or disability discrimination? So this is sticky because you may have employees that are elderly and you're worried about them. They seem frail, they have health conditions, but the employer can't be proactive and ban them from the workplace. If the employee asks for accommodation, then you can have the conversations and you can suggest they work from home or take time off and see what kind of leave you can give them. But if they don't ask for it, you cannot single them out and try to protect them. Just remember, no good deed ever goes unpunished. The primary harassment concerns regarding COVID-19, we've kind of talked about. You can't target people for having been sick, for being exposed, for being in a protected category that people are suspicious of, i.e. Asians. Next slide, please, John. So if you're doing these screening tests before every shift, where do you keep the screening results? You can have a separate file and put all screening results of everyone in there by date, or you can put each employee's screening questionnaire in their separate medical file in your records, however you want to handle it. You're already required by Michigan and federal law to have a separate file for any medical information regarding an employee, and anything COVID related could be placed in that file, whether it's screening questionnaires, information regarding testing, information that they give you regarding their health condition or exposure, anything like that. Emails would go in the separate file. It shouldn't go in their personnel file, but you should keep a record. Same with if an employee tests positive and you require a return to work note, that would go in the separate medical file for the employee. Can you disclose the name of an employee to a public health agency when you learn the employee has tested positive? Yes, you can. And yes, up here, or in Michigan, you're required to. Remember, you have to report within 24 hours when you have an employee who tests positive, and I believe that will include giving the name because the health department will want to do contact tracing to try to contain any potential outbreak. If an employee voluntarily sends a message to other employees about his or her exposure, don't discipline them, don't encourage it, but it might happen and it's going to stir the pot. It is going to cause some people to react, and if it's a violation of any of your email policies, you can talk to the person who sent the email and you can suggest that if they have concerns about things like that, they need to bring them to management and let management handle dissemination of information. But I wouldn't punish them because it's a dicey area right now. Okay, want to talk a little bit about OSHA considerations. I talked previously about OSHA having a guidance on preparing workplaces for COVID-19. The websites are here. They're very useful. Please go on and look at them as you're preparing your return to work plans and dealing with these issues in the workplace. In general, the OSHA guidance requires social distancing, at least 6 feet between coworkers and their workstations where possible. You can establish flexible work hours so people come to work at different times, leave work at different times, have fewer people in the workplace. One of the things under Governor Whitmer's executive order is that retail stores work with the minimum amount of people necessary to operate. So it limits the amount of people in the facility at the same time. You should discourage shared use of phones, tools, desks, or other equipment. Encourage telecommuting or work from home where feasible to limit worksite exposures. Train your workers on how to properly put on, use and wear, take off, and maintain protective clothing and other equipment, including face coverings. And you can, again, look at the CDC and OSHA guidelines on how to do that. The OSHA guidance also includes training workers on how to properly use the PPE, requiring employees to stay away from the workplace and seek medical assistance if ill, whether to allow or require workers to wear face coverings over their nose and mouth, monitor public health communications for COVID-19 recommendations for the workplace, and then provide your workers with access to updated information. Promote covering coughs and sneezes and frequent hand washing with soap and water for 20 seconds. Providing the soap and water and hand sanitizer. Providing disinfectants and disposable towels for cleaning work surfaces, workstations, and work areas. And set up a schedule that you want people to do it every day when they come in and every day before they leave or whatever it is. And be sure that you encourage your workers to safety and health concerns. Again, it's to your benefit to have a guidance to you, not OSHA, so you can address the situation and head off any complaints being filed with OSHA. Another area of concern, for employers is that if you have COVID-19 in your workplace, it might be a recordable event for OSHA. If your company had 10 or less employees at all times during the last calendar year, you don't need to keep OSHA injury and illness records unless you've been told by OSHA that you have to. But all employers other than that who are covered by OSHA have to report any work-related incident that results in a fatality, inpatient hospitalization, amputation, or loss of an eye. The OSHA has opined that COVID-19 is a recordable illness if the case is a confirmed case, they've had a test and it's been confirmed positive, it's work-related, and it involves one or more of the general recording criteria, either death, days away from work, restricted work or transfer to another job, medical treatment beyond first aid, loss of consciousness, or involves a significant injury or illness diagnosed by a licensed healthcare professional. So the key here is it work-related. Michigan's Governor Whitmer has issued an executive order in Michigan that holds that if an employee is exposed, I believe it deals with first responders. So first responders who have work shifts where they've transported patients with COVID-19 and then get it, are presumed to have gotten it at work and presumed to have a compensable work comp injury. I don't think it has spread beyond first responders at this point, but you know, if you have employees who work in a healthcare facility, or you have restaurant servers who are exposed, or front desk clerks or retail staff, and a customer comes in and is exhibiting symptoms, and you later find out that they came down positive, there's potential for that employee to claim that it's work related. We're going to see a lot of work comp cases coming down in the next couple of years, because I don't think the insurance companies are going to be jumping to cover it in a lot of situations, but there are going to be a lot of claims made. And if those employees make work comp claims, then that's probably an OSHA, arguably an OSHA recordable event, because they are claiming that they got it at work. So be alert to that. If there is exposure in the workplace and people come down with it, look at the requirements under OSHA to determine if it's a recordable case, and if so, then you need to log it. OSHA put out an enforcement guidance on April 13th. The link to that is in there. It says that they're going to investigate fatalities and imminent danger exposures as a first priority. Formal complaints alleging unprotected exposures by employees in high or very high risk could warrant on-site inspections. Other workplaces probably aren't going to see inspections. They're otherwise going to follow their non-formal procedures set out in the Field Operations Manual. But if you don't respond adequately as an employer, they might schedule an on-site inspection. And what I've been hearing is that for the employers who've had complaints filed by employees that they think they're being exposed to unsafe conditions, if the employer timely responds with a legitimate explanation, these complaints are getting dismissed. Again, this is all new to everybody, and OSHA's not out there looking to stir up trouble. They have to do their job, and they're concerned about high risk kinds of situations. But just disgruntled employees who don't want to be at work or want extreme measures taken, OSHA's probably not going to be jumping to investigate that, as long as you don't ignore their inquiry. So, you know, if you get one of those inquiries and you're concerned about it, contact your lawyer for some help, and hopefully you can head it off before it ever becomes really an investigation. So, practical considerations under OSHA. How am I on time here? I think I'm running up against time. I'll try to hurry this up. So OSHA requires employers to conduct hazard assessments and isolate sick employees. Physical environment, you can consider one-way hallways. You know, if you can have an indoor and an outdoor, coming indoor and a leaving door as opposed to indoor-outdoor spaces. One-way traffic, you know, even if you can't do one-way hallways, make sure people stick to the one way down the hallway, you know, walking with your right shoulder closest to the wall, either direction, ban people from going in other people's offices or workspaces. You have to consider, are you going to use your break rooms or your kitchens? Are you going to allow people to use the refrigerator? Are they going to use the coffee pot? What about an ice machine? A pop machine? Are you going to shut those things down because they're common contact spaces that would be difficult to keep sanitized? garbage cans that operate with foot pedals as opposed to having to lift a lid, hand sanitizers for personal use. Look at your air circulation. What about your smoking areas? Is there a problem there with not being able to social distance, or people hanging out at the same picnic table and touching the surfaces, whatever it might be? What about touching supply cabinets, elevator buttons, stair rails? You just have to go in and look at your workplace with new eyes and try to sanitize and come up with policies that, try to limit touching of surfaces where germs could be carried. It now sounds like it's not as much of a concern that COVID-19 is transmitted on surfaces, but it's still out there. So be alert to that. Again, flexible traffic and scheduling, flexible coming and going, work hours, lunch hours, things like that, to the extent that you can shift them. That is a good idea. So you spread people out. The more they social distance, the less risk there is for contact in the workplace. So remember the new laws out there, the FFCRA, the paid sick leave law, we did talk about that. That's only in effect until December 31st. But remember, for many of you laid people off, and some people may have been working remotely, or you may have been open, and you may have already had people take advantage of the paid sick law provisions or the expanded family and medical leave. But that is still available to people until December 31st. They only get to take the paid sick leave once, up to the 80 hours. So if they've exhausted it, then you don't have to consider that. If you have employees coming to you, for instance, if they took it to take care of someone else and now they have it, they don't get paid the second go round, regardless of the reason. The same with the expanded childcare, the need for childcare if a daycare is closed or schools are closed. And I anticipate that there might be an uptick in those kinds of requests in the fall. We don't know what going back to school is going to look like. If they stagger school days or school hours and have some kids go mornings, other kids go afternoons, whatever it might look like, then you may, as an employer, get get a bunch of requests again in the fall. So these laws again are only until December 31st, but they're not done. So if it should, your flag should go up if somebody asks for time off because their kids are out of school or their daycare is closed, because these would apply. The CARES Act is the one that expanded the unemployment payments. The unemployment provision expires currently on July 31st, the $600 extra per week, but the 39 weeks of unemployment does not expire. The other provisions of the CARES Act don't expire, and there was an extension, the Senate passed a bill, I think this morning. It's on its way to the White House to be signed, and I have not reviewed it, but it's my understanding that it shored up the Payroll Protection Act. So if you got a payroll protection loan, some of the features are that instead of having to use all the money in an 8-week period, you have 24 weeks to do so. You don't have to call all your employees back by June 30th. You have 5 years instead of 2 to pay back the loan if it's not all forgiven. And I'm, again, not sure what else is in it, but there will be more information coming out. So keep your eyes open for that if you got the payroll protection loans. So what do you do when you start to bring employees back to work? Who are you going to call back? Everybody? If you've got a collective bargaining agreement, you're probably going to do it by seniority. Are you going to look at your business needs, So while you are making those decisions, make sure that you think about the impact. You don't want a disparate impact on your workforce. For instance, avoiding calling back your older employees because you're concerned that they're vulnerable. We talked about that already, but those are the kinds of things that you have to be concerned about. Look at the big picture. What does my workforce look like in general? What do the people I'm calling back look like? What are the people I'm making stay off on furlough or not bringing back, even if they were laid off with the intent that they should be called back if I don't do it? What does that look like? You don't want to discriminate against people, even if it's unintentionally. You have to be alert to those things. Are you going to bring people back full-time or work share? The state of Michigan is allowing employers to call people back part-time and let them get unemployment even though they're being called back to work. So you could call some people back full-time and leave people on unemployment, or you could call everybody back part-time and let them all collect partial unemployment. Those are considerations. Do certain employees have a right to remain off? You have leave of absence policies. You've got some employees probably in a lot of industries where the employees don't want to come back, at least until July 31st. I think there's going to be a stampede of people that want to come back August 1st, as soon as the $600 in extra unemployment expires. But right now, it's pretty attractive to a lot of employees, especially in our seasonal businesses. And what do you do with those people? They don't have a right to stay on unemployment. If you call them back and they refuse, you are supposed to report them to the unemployment agency, and their unemployment should be cut off, which would also cut off the $600 from the feds. You need to have good records just in case it ever blows up, as to who you offered work to and their response. Whether they came back, whether they said, I'm going to stay off until July 31st, whatever it is, have good records. So preparing to reopen. What types of policies do you need before you can reopen? You should consider access control, who you allow in, the questionnaires. You should have an intake procedure for visitors, guidelines for delivery areas, things like that, doors to be used, what people have to do to get back in the workplace. Social distancing, minimize your levels of close contact within the workplace. Have a remote work policy if you're going to do that. Have restrictions on who or how conference rooms and cafeterias, common areas can be used. Consider physical barriers, restrict meeting sizes, then have a sanitation hygiene policy, frequent disinfecting and cleaning, HEPA filters, availability of hand washing, restrictions on shared tooling, a PPE policy, a contact tracing policy. Those are, I think we've covered a lot of other things too. Those are the primary areas where you should consider and have a policy before you bring people back. John, can you go to the next slide, please? We talked about this a little bit, how to handle employees who do not want to return. A number of employees working from home want to continue working from home. Can you order them to return to work in person? It's under the governor's order 110. I don't think you can. I mean, there are going to be employers who do, but if they've been successfully working remotely, the intent is to keep people working remotely, again, promote social distancing. So if they're effectively working from home, you're best if you don't order them back, although I don't think anyone's going to be enforcing it. Even if a complaint's filed and you can say they weren't effectively working from home, you're going to be able to call them in. What if we have an employee who traditionally worked in the office but want to require to work from home moving forward? Can you make the change? Yes, but make sure you're not going to appear to be discriminatory, especially if the person wants to come in the office. Again, if you have elderly people and your reason for wanting to keep them home is to protect them, but they want to come in the office, you really need to revisit that decision. But in general, you can have people work remotely. A lot of employers did it prior to COVID-19 concerns, and you can still do that. We talked about if they're making more on unemployment and don't want to return to work. If you need them, you are supposed to make them come in, and if they won't, you're supposed to report them to unemployment so that they can't take advantage of the system. If you're not covered by the Family First Coronavirus Response Act, what are your obligations to an employee who can't return to in-person work because of childcare obligations? You can give them unpaid time off. You don't have to do so. You can terminate them. I suggest that it's best to allow them to work remotely or shift schedules, but in general, it's not a legally protected reason if you're not covered by the Families First Act. If an employee is scared to return to work, that's not protected either. If they have been told by their doctor that they're at risk for one of the reasons stated by the identified as vulnerable by the CDC, then you might need to do the ADA analysis and give them a leave of absence, but just afraid to come to work is not protected. So those people could be laid off or terminated. And again, if they're in the vulnerable population, it may be an ADA situation where you have to give them additional leave as unpaid, but leave as a reasonable accommodation, because leave is always a reasonable accommodation under the EEOC's interpretation of the ADA. We talked about employees exposed in the workplace. If you can't get PPE in time to reopen, I think that you might need to leave your employees home. See who has masks or the proper equipment. I think there's a lot more available out there than there was. Work with your supply chains, but it would be risky, I think, to require employees to be in the workplace without having the PPE available. If you have employees who say they can't wear masks because of medical reasons, you can get some confirmation, but you have to be really careful how you ask it and what you ask. I think you could require a doctor note to say that the person, I don't think they would have to give you the reason, but that the person for medical reasons is not able to wear a mask. You would really want to follow your standard procedure for any kind of accommodations that employees request. Go through the interactive process, because not wearing a mask because of medical reasons would be a request for an accommodation under the ADA. Boy, I hope I didn't go too far over. I think I got through all the material. John, my screen went blank. I got kicked out. So do we have any more questions?
We don't at the moment, so let me do this. If anyone would like to ask a question, just go ahead and type it in now, and I'll get to it in a second. In the meantime, while we're waiting for that, just let me go ahead and do a couple of little promotional items and follow-up items. First thing, When you log off, you'll get a little survey from us. Please take a second to fill that out. It helps us improve our programs, and we love to get your feedback. The other thing is, I'm just going to quickly promote, if you're interested, we're doing a social media related employment law update on June 11th. You can check that out at our website and register there if you're interested. And also we have on our website our Sophisticated Employer webinar blog. If you're not familiar with it, we cover a lot of material there in real time. You can also include your email address and get alerts when new content is added to the blog. So we encourage you to do that as well. The only question I see here, Laura, and you may or may not be able to answer this one, if you know, are retail and food service type establishments required to report to anyone, whether customers, they become aware of customers that are positive that come into their establishment?
I believe they are, because it's an exposure in the workplace. And remember, you are making the customers wear the masks and follow the rules. I'm not sure if technically you are, but I think it's a really good idea.
Okay, great. I don't see any other questions. We're just probably about 5 minutes past our time, so I think we'll wrap it up. So on behalf of Laura and everybody in our labor and employment group here at Plunkett Cooney, we really appreciate you joining us today, and we wish you a great rest of the day. We'll see you down the road. Take care, everyone.
Thanks for coming, everybody.